Hi everyone, welcome to the webinar. Thanks for taking the time to come in at night. My understanding is you can see and hear me. I can't see or hear you, but if you want to ask questions, you can type into a box and it comes up on my screen and I can answer that. So that's the way this is meant to work. So what I want to do during the webinar, and I'll start using the slides that hopefully you can all see, is report on some findings we, my colleague Steve Davis and I, came up with during our project that was funded by the Bushfire CRC. And from that, we're going to do ongoing work with the Bushfire and Natural Hazards CRC. So I'm going to talk about what we discovered and what we're going to do about it. I'm hoping that we've got an hour that's going to take at most half an hour, and then the other half hour is just open to discussion, not only on this topic that I'm going to talk about, but also anything else that we've been doing through the mainstreaming law and policy project that you might want to talk about or ask questions about. So as I said, if you've got questions, you type them up in the box, apparently. All right. So my theme today was on learning lessons, and really it was about the limitations of the Royal Commission model. So let me just start a bit back from that into our original project. Our original Bushfire CRC project was mainstreaming emergency management into law and policy. We started with the idea that somewhere or other, the law was an impediment to effective emergency management, and that it was inconsistent. We thought that because lots of people tell us that. So we thought we'd look into it. These were our starting premises. Emergency management is a whole of government and cross-sectorial challenge. It needs to be a mainstream issue. It's got to be built into everybody's concerns. We were asking, how does law impact upon emergency management, and in particular, the emergency services? What we found, and we found reasonably early, and we published it in a paper, and I'll put the reference up, is that looking at what people said was a problem with the law and the law's inconsistencies was very much, well, let me withdraw that, not very much, but often an example of people misunderstanding the law. There was, in fact, a fair amount of mainstreaming. There were provisions that required emergency concerns, emergency management, prevention to be considered in law. There was clearly debatable room about how strong the mainstreaming was. So you have a provision, for example, like the Rural Fires Act and the Environmental Planning and Assessment Act, both in New South Wales, about building in bushfire-prone areas. Emergency management is certainly a concern. It may not be the only concern. In some other areas, it may not even be the dominant concern, but it's certainly there. Now, how strong emergency management should be, what its priorities should be, is of course just a debatable point, a political point. You've got to make compromises on these things. But a large amount of mainstreaming did exist. And when lots of people reported things, and if I can paraphrase some evidence before the Royal Commission, people would say, you know, hazard reduction burning is ridiculous, we're not allowed to do it. The answer is, well, you are allowed to do it, but there may be procedures and processes you have to go through, and that's because there really are various other competing interests that have to be balanced. And it's a standard position in law that no one should be judging their own cause, so we don't let an individual decide whether their hazard reduction is more important than their neighbour's amenity or the ecological protection of some species or the protection of other assets. Somebody else who's a bit more arm's length has to make the decision. It's different organisations in different jurisdictions, whether it's a fire service or a tribunal or a council. Ultimately, there's someone there, so you can do these things. You just got to go through the process. The process can be pretty tedious, I'll grant you, but it's not that it's not there. So what we discovered, in fact, was that mainstreaming emergency management into law was probably around more than people thought it was. But agencies were still having trouble understanding their obligations and their responsibilities. And we discovered not that The concern with emergency management was the problem, but some other things were the problem, and here's where we get to today's theme. What did we learn? We learned there may be mainstreaming, but it's actually hard to know what anybody's meant to be doing, so it's hard to know who's doing a good job. It's hard to know what a good job looks like. So, for example, and I know it's callous of me, and I've said it before, and if anyone was here during the Black Saturday fires, I apologise if this is distressing. But there is an argument, at least, that even though 173 people died on Black Saturday, that's in fact evidence of a really good job. It was a really bad day. And then Mick Kelty, when he did a review of the West Australian fires, said just because no one died didn't prove that it was a good job, because lots of properties were lost. So what's really missing is some clear measure of success. What are we trying to achieve? If the emergency management sector is trying to achieve a perfect record, there are no bushfires and no one ever dies in one, that's unrealistic. That can't be the measure of a good job. So one of the things that's missing is the measure of success. One of the other things that we learned, and this is what I want to talk about tonight, is that we may not have the best model to learn from past experience. I've got into reference there, see Eburn and Dover's Australian Journal of Public Administration forthcoming. So we have an article that's coming out, and what I'm going to now spend the rest of the evening touching on is that paper, what we wrote, what we thought, what we found. So let me start with a quote. Some of you may have heard it, allegedly from Einstein, who said insanity is doing the same thing over and over again and expecting different results. What we have argued is that the insanity may not lie in responding to fires or having the emergency services do what they do, and yet having yet another fire. Insanity isn't going, my goodness, we're obviously doing the same thing wrong, doing something wrong, and yet we keep doing it. Perhaps the insanity is after these events we keep having a quasi-judicial process. What I mean by that is a coroner's inquest or a royal commission, and expect it to teach us something useful, and then when the next event happens, we do it again. Perhaps what we should be saying is perhaps we're using the wrong process to learn the useful lesson. See our nice summary there. It's time to do the post-event review in a different way. See if that doesn't produce different results. So our insanity maybe is not we have the emergency services doing what they do, so we keep holding these inquiries after the event and going, right, we've learned that lesson, it won't happen again. So let me now explain in more detail why we said it. Sue has just asked me a question saying, am I suggesting that critical success factors should be enshrined in law, or which should they be? Sue, I don't think they should be enshrined in law, and if I may, I'll come back to that question when I've finished describing this. So why did we come to that conclusion? Well, let's do some history. We can have post-event reviews in a whole number of ways. They can be simply internal or departmental or agency inquiries, and we've seen those sorts of things like the McLeod inquiry into the 2003 Canberra fires. We can have inquiries under existing legislation. The model there would be some of these inquiries Mick Kelty's been doing in Western Australia. We have ministerial or parliamentary inquiries, and again, there was a parliamentary House of Representatives inquiry into the 2003 Canberra fires. And then we have the ultimate is the Royal Commission, 2009 Bushfires Royal Commission being the most recent example of that. Also in there should be the coronial inquest, which is a very specialised inquiry, and I'm going to touch on that with the Royal Commission. Now, I've talked about quasi-judicial inquiries. I call them that because they look like a court. You go into a Royal Commission or a coroner's inquest, it looks like a court, using probably a courtroom. There'll be a bench, someone sitting up high. It'll be staffed by lawyers. Royal Commissioners are usually judges. Coroners are always magistrates. They'll be assisted by counsel. They have a tendency to adopt courtroom procedures and behaviour. Witnesses are examined in chief and cross-examined, and documents are put to them, and lawyers tend to fall into their old professional practices because it's what they're used to, and it's quite effective at getting at the truth, or at least revealing things that people may not want to reveal. There are two types of these quasi-judicial inquiries. There's the coroner. Coroners, in fact, date back to the 12th century. They are one of the oldest officers in law. They have traditionally and still do investigate deaths and fires, and in some jurisdictions, explosions and disasters. They meant to have a limited jurisdiction. A coroner is meant to determine the identity of the deceased, the manner of their death, the time of their death, and in some cases whether they are in fact dead, because if you've got someone who's disappeared, you've got no body, you need someone to sign off the documents to say they're dead so you can access bank accounts and life insurance. People can get on. So that's the role of the coroner. When it comes to fires, their role was also to investigate the cause of fires. And while I'm not going to go into that in great detail, that was certainly a matter of controversy in the Canberra inquest, where it was argued that the coroner had gone way beyond her remit when she was investigating how the fire services had responded to that fire. The argument was the cause of fire was a lightning strike. That's all she needed to say. That inquiry certainly went wider than that. I won't go through the legal justification for that. The other quasi-judicial commission that we're talking about is a Royal Commission. It's an ad hoc inquiry, by which I mean they don't exist. It's not like coroners. Coroners are employed, they're there, they're sitting as magistrates, they're ready to take on the role at the drop of a hat. A Royal Commission is established in response to a particular event, and they're limited by their terms of reference. So they are given a particular remit on what they are to investigate and what they are to do. They're classic. What sets them apart from all those other inquiries is they're independent. Although they're called by government, although they're funded by government, they are independent of government. No one can tell a Royal Commissioner how to conduct their investigation, and there's no doubt that they turn up things that are embarrassing to governments. In fact, that's often why governments call them. They have coercive powers. That's important. They can force people to say things they don't want to say. So if you're called before a Royal Commission, you may be required to answer questions, whereas in other tribunals you would have the right to refuse to answer them. You can be compelled to produce documents. They take evidence in public, so they're seen. The public can come in and watch, so there's no suggestion that anything's being hidden. Always a problem with sort of internal governmental inquiries. The Royal Commission is the top of the tree. It's the high-profile way where governments say, we take this seriously. We join with you, the community, and we take this very seriously, and we're going to get to the bottom of it. But they have their limitations. They have their limitations in the context of emergency management and emergency response. To start, they're going to look at a particular event rather than the policy as a whole. And that's always going to be, you could argue that. Take the 2009 Victorian Bushfires Royal Commission. Sure, it looked at hazard reduction burning, you might say, as a policy as a whole. But ultimately, it's looking at, well, what was the impact on hazard reduction burning on this event? So you might get a Royal Commission that says, well, we should do much more hazard reduction burning, because if we did, this event wouldn't have been so bad. But they may not then look into, but what would be the impact of that hazard reduction burning on some other interest? What's it going to do to the forests or the native species? So in that sense, the recommendations that come out of Royal Commissions may conflict with other policy objectives. They're not briefed or required to take those other ones into account. A real problem with them, in my view, is they don't very well, believe it or not, test the submissions of witnesses. Royal Commissions may do this better than some. Certainly, the Royal Commission into the Queensland floods, the parliamentary inquiry into the 2003 Canberra fires, and I appreciate that's not one of these quasi-judicial inquiries, but they all do it. They tend to report things that witnesses have said as if they're true, when they may not be. In my discipline area, which is where I'm confident to speak, it comes back to this question that made us all start in the first place. Witnesses keep turning up and saying how terrible the law is, and that gets reported in a Royal Commission report with a recommendation to make some change, because the Royal Commissioners, they're new to the whole thing. They're not over the discipline, and so then they make recommendations that really, from an informed point of view, are not very helpful. I have to say, if they do that in the discipline of which I am quite familiar, my bet is they do it in the other ones too. And you participants here probably know that better than I do. I've spoken to plenty of people in the fire services. Indeed, you get recommendations that really aren't very helpful, because somebody's gone in and had a go, said their view, and it's been adopted as true when it may not be. One of the other big problems with Royal Commissions, and the reason they do this is what I'm about to say next, is Their recommendations aren't binding. No one has to accept them. One of the things they may not do is consider the budget implications. And they would say, I think rightly, yes, of course we don't. We'll make a recommendation that's intended to reduce the risk of the next hazard. It's up to government to decide whether they want to pay for it or not. But there's a couple that you can see on that slide that have come out. So the 2009 Victorian Bushfires Royal Commission recommended burying the power lines. The Power Safety Task Force has gone out, surveyed people, looked at what that would cost, and the general consensus is the community is just not prepared to pay the price that it would cost to bury those power lines, regardless of the increased safety. To buy a Sky Crane helicopter, it should be a Sky Crane, not an Sky Crane, sorry about that. Helicopter came out of the inquiry into the Wangari fires in South Australia, where the coroner recommended that the South Australian Country Fire Service should buy one of these helicopters. I'm sure if the Country Fire Service had a budget that would allow them to buy one, they'd probably think of other things to spend their money on. We now know that we have a national strategy where helicopters and other assets are chartered on a national basis, made available to the states, because for any one state to buy one of these things and have it sitting around for a large part of the year is just implausible. But that's the recommendation that comes out of these tribunals, because that was a coroner's inquest. One of the other problems with these inquiries is what happens to them. Well, believe it or not, it's hard to know. The 2009 Victorian Royal Commission recommended, and there is an implementation monitor, and that's a first. That's where there is someone who was actually put in charge of monitoring it and reporting back to government what was happening. The coroner's recommendations, we've got some other figures for, which I'll come to in just a second. But I think it's probably surprising. People think that once these recommendations are made, governments must know about them and act on them and take them all very seriously, when really that doesn't have to happen. A study of coroner's recommendations made in 2004, so the researchers found all the inquiry recommendations they could from 2004. For some of the smaller jurisdictions, the ACT, the Northern Territory and Tasmania, I think it was, they expanded the years a bit because there just weren't enough in any one year in those very small popular states and territories. But roughly speaking, we can say 2004. Well, they discovered that 44% of the coroner's recommendations were implemented or partially implemented, less than half. 13% were not implemented. The coroner had made a recommendation and the agency had either chosen not to do anything or neglected to do something about it. But they could at least go, yes, we knew of that recommendation. No, we haven't done anything. 43%, nobody could tell. There was simply no way of being able to identify whether or not anybody had done anything in response to that recommendation or not. So here we have these systems that we believe are investigating these events, making recommendations that we hope are going to resolve issues, and there's 43% of them just being lost in the system. They're not implemented or not implemented, they're just disappearing. There have been some amendments to coroner's legislation since that time and in light of those recommendations to try and improve those numbers, but they're still disturbing numbers. Here's another problem that we found with respect to these particular inquiries, and it may be one that touches a nerve with some of the people partaking here. They're scary. Now, there are 2 points here. Many inquiries report that volunteers fear liability. Well, we did a study and said, look, that's not really what people fear. What they really fear is this sort of scrutiny. People say liability. They come to these royal commissions and they say they're scared of liability. It gets reported as an issue. It then gets a recommendation that there be some law change to protect volunteers, when that's not actually the problem. Volunteers aren't liable for their actions. What they're scared of, as our study showed, is, and what they use liability, they talk about being liable when they mean being aggressively questioned by a coroner or counsel assisting in an inquiry. So in that sense, we have an inquiry that, sure, needs to be independent, needs to convince the public that we're doing things to identify lessons out of these sorts of catastrophic events. But it needs to be arm's length from the agencies. But we're doing it at perhaps a very high price if our members, and in particular our volunteers, are saying, I'm not prepared to pay that price? Who would want to be a volunteer? And maybe a volunteer didn't get grilled in the 2009 Victorian Bushfires Royal Commission. They certainly saw their bosses getting grilled, and that translates down. So that's a problem. Who wants a Rolls-Royce system of inquiry that's scaring everybody? One answer to that question is that that's the very point of Royal Commission. Historically, Royal Commissions have done all sorts of things. Governments would hold a Royal Commission to find out on some policy issue. But now they've got government departments and experts, consultants. They can get that advice other ways. So the big role of Royal Commissions, and we've seen it, we've all seen it, the Wood Royal Commission into New South Wales Police, the Fitzgerald Commission into Queensland Police, the Standing Commission that is the ICAC in New South Wales. We have those inquiries, and that's when you need those coercive powers, because you want to get people to tell you things that they really would rather not tell you. And you want to hide, and you want to bring out everything they're trying to hide. So you want that process where there is no room to hide. When you're in there, you know, everything will be revealed. My fear, and I don't have evidence of this, but my fear is that applying that model to a post-event inquiry says to the public, we reckon the fire services or the emergency services have something to hide. Noreen just asked, are there examples of how inquiries are conducted in genuine, exploratory and learning way? And again, Noreen, I'm coming to that. So I've now got two questions, which I've done the traditional academic thing. I said, I'm going to come back to those. So so we've got this system, and it's causing us these costs. The other fear, and again, we don't have a lot of evidence on this, but we did in our research that we've done, raised this question for us, is that people believe, whoever people might be, the community, whatever, that if we've had a Royal Commission, it won't happen again. You know, we've had the Royal Commission, we know what went wrong, that will never happen again, we can all get on with our lives, and of course, people in this audience know, of course it's going to happen again. You know, there will be another cyclone, there will be another devastating fire. All the climate change reports say there are going to be more of them and they're going to be worse. And so the problem, the perception, that's as best as I can put it at the moment, and we can go through the newspaper headlines to support that claim, but the perception is when the next catastrophic event comes, it's let's line the next fire commissioner up, because clearly they haven't learned the lessons, because they had a Royal Commission, this shouldn't have been allowed to happen again. Not. The lesson we don't learn from the Royal Commission is these things are inevitable. So that's where our bushfire CRC research took us, just to that point. So it raised the question, what we've done. I can't justify all those claims with evidence, but we think that's the problem. So we think that there's something to discover here, and we should look at them. Here are some suggestions, and this is what we're going to begin to explore with the new Bushfire and Natural Hazards CRC. What if we reframe the terms of reference? What if a Royal Commission was held to inquire not what went wrong, but what went well? What if the next terms of reference said, although it was tragic that people died, it could have been much worse. The community and its government did a fantastic job. Let's go in there and see what they did well. Of course, you're still going to find out what didn't go so well, but what if we focus on that? Would that make a difference? Come to Noreen's question, can we learn from other industries? Certainly, the medical profession is moving to what they call open disclosure. So there are procedures in place where if there's been an adverse medical outcome, your doctor is encouraged to report it to you, tell you what went wrong, best explanation as to why it went wrong, what they're going to do about it. There are all sorts of liability protections in there so that it's not seen as an admission of liability. Not that liability should be such a big thing. We're all taught that if you do something wrong and it hurts someone, we should make it good. That's the basic premise of liability. So if there was a medical misadventure because they left the sutures in or the piece of equipment in your abdomen, they're going to be liable. Everyone knows that. The other model that we want to explore, as I said, these are just our thoughts for the future, and we'd certainly welcome feedback of what people think about this, is the aviation industry. The aviation industry allegedly has a no-fault system of inquiry, and they certainly encourage near-miss reporting. So we know that, and you've seen it recently in newspapers, when 2 Qantas aircraft flew reasonably close to each other over Adelaide, it gets reported, it gets investigated. No one necessarily loses their job. Of course, we do know that often enough these inquiries do say it was the pilot's error. Sometimes that will be true. And the fire and emergency services can't avoid that either. Sometimes if their report says they really mucked it up, well, hey, you've got to take that on the chin. But maybe the aviation industry has something to teach us about a way of investigating these incidents without sacrificing the goodwill of the people who were in it. And some of the differences, to come back to Noreen's question, to remind you, she said other inquiries of how these are done in a genuine exploratory way. These are done by the industry, by people who know the industry, so aren't overwhelmed or taken by surprise or find things surprising. They know it. Somehow they manage, certainly I think the aviation industry does, to maintain public confidence. I think most of us are fairly confident that the aviation investigating processes work pretty well, and one of the reasons, of course, we're confident about that is aeroplanes tend not to fall out of the sky very often. But they've obviously maintained some way of doing that. We want to look into that. We want to ask, how are they doing that? The other model we want to look at, Roshan has just put up, how about learning from bushfires in the international context? And that's the very point I'm about to get next to. One of the things we want to look at is the US Wildland Fire Lessons Learned Centre. We want to ask, how are they doing lessons learned? How are they maintaining public confidence that they're not simply the agencies looking after themselves and doing a whitewash? So that's certainly a model that we want to go to and ask, how do they work? How do they maintain public confidence? How do they write reports? Are they accepted? Are lessons picked up from those? And there will be, no doubt, other comparative centres in comparative countries, and the ones we would most closely compare with, I would have thought, again, at the start of the project, would be probably Canada and New Zealand. I'm not quite sure how they engage in that process, but they would be things we want to look at. See if there are models there that we can pick up and bring here. We would be less inclined to go to the UK because they don't have the fire risk. Of course, the bushfire and natural hazards is all hazards, and they do a lot with flooding. So there's certainly stuff to be learned there. And other countries like Spain, big fire-prone country, they have quite a different legal system. So I suspect that Canada, New Zealand, the UK will also be places we want to study, but certainly we want to get into the US Wildland Fire Lessons Learned Centre and see how they're working. So that's one thing. Now, the other thing we're suggesting, and again, just an idea, this is what's going to be the subject of our research, not something I can defend, is a new model of inquiry. We're going to suggest that you have an overarching panel of inquiry, a bit like the 2009 Victorian Bushfires Royal Commission. When they started, they went out, they did the community consultations, very quickly had some inquiries, identify what the sorts of issues are, and then create specialist panels that can look at those particular issues from a position of detailed knowledge. So you're not having, as we did there, 3 Royal Commissioners, assisted by all those council, trying to get their head across everything. Have a number of specialist panels reporting back to the overarching inquiry. And certainly if you did that and you began to think that there was something that someone was trying to hide, that there was something that was being covered up, you could then go and use the coercive powers of the Royal Commission, drop back into that much more inquisitorial system if you needed to, but without starting at that process. So we want to look at that and see whether that's a model that might be something useful. It'll be, we don't know. So, developing these ideas. That's going to be the subject of our ongoing research with the Bushfire and Natural Hazards CRC. We hope to make recommendations for a better approach to learning lessons that doesn't forsake the goodwill, and in particular the goodwill of volunteers. I should add, we haven't discussed it, but we're aware that the Attorney General, Commonwealth Attorney General, has done a big project on better ways to learn lessons, and we'll certainly be drawing on that. All right, that's the theme that I wanted to talk about. Let me just quickly have a look at the questions. I've addressed, I think, Noreen's. I'll come back. Still got Sue's in mind. Sandra has said, it would seem the purpose of inquiry commission is to meet public expectations or a political motive. Look, there's certainly some evidence and some research that says that's one of the reasons why royal commissions may be called. Governments can call them for a lot of reasons. Governments cannot call them. You know, the witticism is, of course, you never call a Royal Commission unless you know what it's going to find, because it can be embarrassing. Look, that's not true. Of course, they call Royal Commissions and all sorts of embarrassing things are discovered. They call them when they realise that there's just no way out of it. The public won't tolerate anything else. Where they call it when you get something like the Fitzgerald inquiry, where you realise, in fact, that your own agencies really are so on the nose that you've got to get in there and clean them up. So in that sense, it's not always expectations of political motive, but look, I think there's a certain amount in it. I'm going to go out on a limb here. I would say, you know, Chatham House rules, but who am I kidding? This is being recorded and you're all here. Oh, and look, I just see Mark Cuthbert's on, acknowledge Mark and the lessons learned program that's been working through Attorney General. And we engage with that, but I digress. What I was saying is about Royal Commissions. It always struck me, and again, I'm being out on a limb here, that calling the Victorian Bushfires Royal Commission was an amazingly politically astute thing to do, particularly so soon after the fires, because it just allowed the government to say, we can't talk about that before a Royal Commission, and let the emotion out of the whole situation by the time they get an inquiry that you can get on it. Now, they could get on with other things. And researchers on Royal Commissions have said that there's evidence that, you know, you can calling a Royal Commission to buy time is not a bad thing to do. It just stops the public debate to a certain extent. You can't comment on that. There's a Royal Commission. So sometimes Royal Commissions are called, I think, to meet public expectations, certainly, and there's no harm in that. That's what governments are for. And a political motive, well, that may also not be true. How do we think the new model would sit with community expectation? I think that's the challenge. How do you develop a new model, particularly if you go to something like the aviation industry or something like the US Wildland Fire Lessons Learned Centre, and maintain public confidence? If the public think it's just the agencies investigating themselves, then it won't meet community expectations and it won't work. So that's the real critical question that we're going to go out and try and see if we can't find some answers to, because that's essential. All right, if I can move on then. Just to put up some other themes from our research: mainstreaming fire and emergency management law, what does success look like, sharing responsibility, volunteers and emergency services. We've got, I've taken my half hour. I'm happy to throw those open to questions and just talk about any of them. I know it's a bit of a bizarre system that you have to type your questions and I speak the answers, but let's see if that works. We can go back to Sue's question about, should I think measures of success should be enshrined in law? No, I don't think they should. I think that would be unnecessarily restrictive. You could never say in law, this is what success looks like. What I really think has to happen is the agencies have to decide for themselves what they think is a good job, and they need to convince their ministers what's possible. Minister, you cannot expect this, you can expect that. And then, and this is the hard thing, governments and the agencies need to be brave enough at times, I think, to stand up and go, even when the outcome has been not ideal, you know, we think we did a good job. I mean, the community may not buy that. That's fine. You know, we live in a democracy. The community can express its views other ways, but I think ultimately the agencies need to have in their own mind a view of what they think success looks like, so they can defend their position if they're not sure what it looks like. And I think, again, going out on a limb, I think it's bold to say that success is no one ever dies, but maybe it's not. But if that is your measure of success, then say it. Because if that is the measure of success, then you take a very different response than if you have some other measure. If your measure of success is that no one will die in a bushfire or a flood, then you're going to be much more insistent that people do what they're told. You're going to want to use draconian compulsory evacuation orders. You're going to drag people kicking and screaming out of property, and you're going to have to wear, as Mick Kelty discovered after the Perth Hills fires, that your property losses will go up. The science still says, maybe not on catastrophic fire days, but my understanding is the science still says homes, can save you by protecting you from the radiant heat, but also on a well-prepared, well-defended home can be saved. But if you take everybody out of those, you're going to lose property. Perhaps you, in fact, if you really want to make sure that your measure of success is no one dies, you give up on this shared responsibility idea. It's not shared responsibility. We're responsible. We're going to tell you you're going to get out. Nobody will die. Property will be lost. Okay, well, that's a measure of success. If that's the one the agencies want to go with, be explicit. They're the consequences. And if that's what you've said, and if that's your policy statement, then when a lot of houses die, you can say to the inquiry, no, it was an absolute success. What we wanted to do was make sure no one died, and no one died. That's brave. But until we do it, I think the agencies are stuck at it. I'm just reading a question that Noreen's put up. Sometimes government simply can't protect everyone, and I agree entirely, and I think that's part of the problem. And then it says, but there seems to be a protective culture in the EM sector. That's right. I mean, emergency people, management people, it's obviously why they're in the business. They love saving people. That's ultimately what they want to do. And so when I have conversations with the emergency management sector, and people talk about, I'll paraphrase a bit here, but why aren't people getting the lessons in there? Why do they make silly decisions like stay and defend their home that's undefendable, or go back for the pets? And it's because people have different priorities and different values, and those things are important. And if you think your objective is you've got to save everybody, well, that's a failure. But if, for example, your objective is what you want is people to make informed decisions, and someone makes an informed and rational decision, I think my home is well prepared, I think I'm well prepared, I've done the best I can, I'm going to stay and defend, I appreciate that there's a risk I'm going to die, and then they do die, well, if your measure of success was people will make informed decisions, their death is not a failure. Their death is just the residual risk. They were informed, they did the best they could. There was always a chance they were going to die, just like there's always a chance you're going to win the lottery. It's incredibly unlikely, but it might happen. That's what that is. So I agree, Noreen, that I think in some sense the emergency sector is its own worst enemy. We can take that into another context. Again, it's in the shared responsibility field where the argument is we want people to share responsibility. This is particularly true in the SES sector, and then people go, but why do they ring us? It's just a tree down on their lawn, or it's a tree on the roof, but there are 3 young blokes, they could get up there and fix it. Yet the emergency management sector has spent its time going, call us. People will have heard me say this before. The message from the SES is not for emergency help and floods and storms, sort it out yourself. The message is for emergency help and floods and storms, call us, and we'll come. And we don't want a whole bunch of young blokes getting on the roof who aren't trained and don't have roof harnesses and don't know what they're doing. So of course we're going to get up there and do it. So in that sense, we're our own worst enemy again, where we've got this, as Noreen has said, this protective culture, this idea that particularly volunteers, if I can be so bold, but I think particularly volunteers, they want to get out there and do it. They love it. I say that being one of them, we love doing it. But then you can't complain that people call us and ask us to do it, or that they're not sharing responsibility. They are. In fact, the measure of success should be that they do, in fact, ring us, that they recognise that they shouldn't climb on roofs. If you can put it in the paramedic context, when people go, why do they ring an ambulance when it's not really a health emergency? Well, one argument is they're being incredibly resilient. They understand, I shouldn't just sit here and go, no, it's all right, I'll be okay. They should go, actually, maybe I'm not well, I'll call an ambulance. That's what being resilient is. It's to understand that I should call someone else. So I think the emergency management sector sends out these conflicting messages, and that I think is part of the problem with this whole idea of measures of success. You've got to know what they are and then stand by them. Can I comment on how I would legislate for shared responsibility? That's another question from Sue. There's an interesting article, I should say. Of course it's an interesting article. McLennan and Eburn, so Blythe McLennan from RIT and I wrote. And we wrote that because we were trying to write a paper on shared responsibility. Blythe has been doing a project with the Bushfire CRC on shared responsibility from a community perspective. And I guess, Sue, she asked me something similar. How would you legislate for it? And we tried to start writing this paper and realised we were using the same words and meaning very different things. And we had different priorities. And so we sat down and tried to write an article about what legislating shared responsibility might mean. And we ended up drawing up an axis, X-I-S. Hold this up to the diagram. You know what I mean? That sort of diagram. 2 points. And at the extremes of the point, we argued, you know, is our measure of success community benefit, or is it individual benefit? Is it personal autonomy, or is it, you know, communitarian values? Do we allow people to do themselves? And we came up with all these various models of what the legislation might look like, depending on where on these axes you thought you should fit. And the point was that, again, it's a matter for discussion. Governments, agencies, the community have to talk about this. And Noreen's just asked me, and Alan, I see your question, I'll come back to that. Noreen's asked me a question: when does protecting individuals for their own good extend to infringing an individual's right to make decisions? And that's a fundamental question that comes back to, how do you legislate for shared responsibility? If shared responsibility really is, you are responsible for your decisions, and you can choose to stay and defend your home and die if you want to. Or is shared responsibility, as one chief officer responded in the questions we put to them as part of our research, he said, it's our responsibility to tell people what to do, and it's their responsibility to do it. Well, that's one model of shared responsibility. Another model is, it's our responsibility to give people information upon which to make decisions. It's their responsibility to make those decisions and wear the consequences. Governments and agents, I think governments led by agencies. I think agencies need to be in the ear of their ministers, talking about where we sit as a community on that line. What is it? What does it mean? And that answers in part to your question of how would you legislate for it. So Alan said, are fire and emergency agencies responsible as to whether these people's homes are defendable? And the answer is no, they're not. It's their home. People want to live in an indefensible home, surely that's a whole lot of their business. If there's anyone responsible, it's ultimately, I would have thought, local government. Local governments have the obligations to enforce and maintain whatever hazard protection rules there are, but they're pretty loose. And secondly, they just don't have the resources. I mean, why on earth is local government going to spend its time going around insisting somebody maintain their asset protection zone around their home? You know, their home. It's a whole lot of their problem. I would have thought there'd be a room for the insurance industry. They might well want to take a more active role in that. Look, we'll give you a premium deduction. There's been some suggestion that, you know, you should register your house effectively. So you need to have an annual inspection that your asset protection zones are maintained. If you're in flood-prone land, whatever you might do, of course, once a house is built up, I suppose it's built up. But again, and now I'm wandering out of my field of expertise, but this is just what strikes me as true. The insurance industries aren't very interested because, you know what? They're not making a loss. They insure your house and charge you a premium for the risk. Your house burns down, they pay out, they're still making money. I noticed, I saw some headlines the other day that QBE were in a bit of trouble, so maybe there's some evidence that that's not true. But certainly after the Canberra 2003 fires, none of the insurance companies went broke. It wasn't a major burden to them. Victoria was a bit bigger, certainly lost more houses. The insurance company actually plans to lose, there was a report, about 2,500 homes a year anyway. They're not going broke. So it doesn't really worry them, I don't think, a whole lot whether some houses burn down. They're still making a profit. If they weren't, they may well want to take some more action, but their standard action would be put premium up. Provided they're charging an actuary discount premium, they're doing all right. So no, Alan, fire and emergency agencies are not responsible as to whether people's homes are defendable. They may be responsible to give them some advice, but at the end of the day, they are not responsible. Governments are not responsible, are not legally required. Let me stand on firm ground for my discipline. They're not legally required to save everybody. All right, I think they're the questions I've got. Anyone else want to throw anything at me? Raise any questions? I'm going to put up the next slide while you're thinking about it, which is some of our publications, which may also inspire you to ask a question. There's some of the things we've written out of this Bushfire and CRC project. And you can see some of them are coming. Oh, there's that Eburn and McLennan paper I was talking about, exposing hidden value trade-offs, sharing wildfire management responsibility, and that's forthcoming in the International Journal of Wildland Fire. and sue on the measures of success. Where as you can see, we've got a paper coming out. We don't know if it's coming out. It's been submitted to the Australian Journal of Emergency Management, so it's still going through the review process. Anything else I can talk to anyone around? As I said, it's very odd. I'm sort of talking to myself, looking for you to type things up, but whose comment there is, that's great, Michael. Thanks, you're welcome, Sue. Had a little arrow. I didn't know what it meant, but now it's gone away, so I still don't know what it means. There's all sorts of little symbols that I can see. I don't know if you can or not. Daryl has asked, in mainstreaming fire and emergency law, should all states and territories adopt the same legislation to minimise confusion? I'm not a fan of that. Again, that's a discipline perspective. I understand the nature of the federation that we live in, and the whole point is that the states don't have to be the same. The whole rationale for the federation is they are different, and they're meant to represent their different communities. The question would be, where does interstate differences cause confusion or problems? The obvious area I would have thought is when agencies have to cross borders. So if you're in rural fire service and you're travelling to Queensland or Victoria, vice versa, when the CFA are moving around, at least to make sure I cover the agencies. I'm sure you're all on there. That may cause some confusion, but generally speaking, the value of having state differences is there are state differences, and it also allows experimentation. One state can try something, another state can try something else, and you can make decisions about what works and try and learn the lessons. So there are two ways of answering Daryl's question. One is, should the Commonwealth be doing all this? Well, the Commonwealth can't. It certainly just simply doesn't have the constitutional power, and it's so far removed from on the ground that it would be, I think, a terrible mistake to think the Commonwealth would do EM on a national level better than the states do. The other way is, should the states cooperate? Well, they do, and we have a whole lot of systems to bring them together, and AFAC, Emergency Management Australia, Bushfire and Natural Hazard CRC, the Bushfire CRC, is doing that and allowing the sharing of lessons. I wouldn't want to go so far as to say they all have to be the same. That's contrary to the whole nation of the Federation. So as I say, maybe that's a disciplinary bias. As a lawyer, you think, no, that's not a good reason. But I haven't actually seen enough evidence that state differences are a problem to in my mind, justify doing Richard has asked, Michael, do you suggest that we adopt the CASA, C-A-S-A, Civil Aviation Safety Authority Type Forum, to take away the limitations of court processes? Further, we often see limitations in presenting electronic evidence, which is also awkward in traditional court. Do you think a different forum would assist with this too? Certainly, yes. The first point, yes, we want to explore the CASA model and see whether that would be a useful model in this area. As I said, that's the question we want to ask. I don't have an answer to it. If I did, we wouldn't have research to do. But that's the question I do want to ask. I want to look at that CASA forum, the CASA model, and say, is there something in there that we can learn from? Yeah, look, with respect to electronic evidence, I think courts are catching up. You know, judges, may not be the most recent takers up. That's not the right phrase, but I can't think of a better one, of technology. But they're getting there. So we'll have, electronic records management, electronic evidence will just constantly improve as we go along. So Richard said, how can we progress this? And the answer is, well, that's what we've got a grant from the Bushfire and Natural Hazard CRC to do. So we'll be going to CASA and talking to them about how they do their business. We'll come up with some evidence from them about what goes on, and then I anticipate we'll be coming out to the sector and saying, would this work? Would this help? What are the limitations? What are the ups? What are the downs? How could it work? How do we achieve what needs to be achieved? Because you have to concede, as I'm sure CASA would, But sometimes it really is human error, and you have to be able to say it. So this desire to protect the goodwill of the industry can't be at the cost where you can't call a spade, and when something goes horribly wrong because somebody just didn't get it right, that it's not said. So finding that balance will be hard. How can we progress this? Watch this space. That's what the Bushfire Natural Hazard CRC research project will be doing. Now I see some people have little smiley faces next to their name. I hope that's positive feedback. I'm asked to remind you that this is being recorded and will be placed up on the Bushfire CRC and probably the AFAC website. While I'm at it, I should also put a plug in. I did an interview with the Emergency Planning College at York, just outside of York in the United Kingdom, which they videoed and put up, and there's a link to that from the Bushfire CRC page too. And I can be so bold of that interview. So if you want to hear more about, Eburn's thoughts, touching on some of the things that I've just mentioned here, you could go and have a look at that. Good enough for me. People get little letters next to their name. I'm not sure if that means someone's typing. But anything else I can? Assist people with? Anything else anyone wants to comment on? I know the CRC are keen to do these webinar things, and I understand they're going to try and ask some questions about what other topics you'd like covered. So, and certainly if there's anything from our research you'd like us to address, so certainly on to that survey, however that comes out. Richard's asked, are you familiar with the North American model in this regard to post-fire hearings, i.e. what does Canada do, etc.? My answer is no, not familiar other than with the, as I said, the US Wildland Fire Lessons Learned Centre. But again, we want to get out there and we want to find that out, particularly from those countries that I said, like Canada and New Zealand, that share a common legal traditions from the English common law. I'm not sure that the Spanish or the European would be as a value to us because they have a quite different legal system. So we'll be looking at, again, part of our next project, as part of this ongoing research project, to how they're doing that, and starting with the US Wildland Fire Lessons Learned Centre. And yes, I've now been told, in light of what I was saying, that yes, there's this exit survey at the end of the webinar where they're going to ask you what you thought of it and what other things you'd like to be covered. So please take the second or two to do that. I'm told it's very short. Just coming back to what does Canada do? As I said, Canada has the same sort of legal system now, so I am aware that they have the Royal Commission model. If that's what they do after their fires, I'm not exactly sure, but they certainly have Royal Commission. They have that same idea that we do, and it comes from that common English heritage. You can tell from the phrase Royal Commission that it's a pretty old model handed down to us from the UK. Yeah, Richard said certainly across the civil litigation in the US. Yeah, it's the old story. People say in America everybody sues everyone, and you go, oh, look, it's not really not true, and then you look into it and go, yes, it really is. They do sue each other. It appears to be the drop of a hat. In one sense, people say that's a bad thing. Actually, lots of people, you can make an argument that it's a really good thing. That the whole point of having law is that it's meant to regulate behaviours and regulate relationships, and so that people are going to law means that it's actually accessible. One of the reasons we don't sue each other nearly as much, without beginning to comment on sociological reasons why, I couldn't begin to answer that, but it's actually bloody hard and expensive. I don't know about you, but I couldn't afford to go to a lawyer. I'm sure most people couldn't. So in fact, we have this Rolls-Royce legal system that you just can't get into. The Americans have got over that. You can. In one sense, people see that as, depending on where you stand, it's this terrible tragedy that the place is run by law. But if you actually believe in the rule of law, it's actually saying, well, the law's there, it's being used, that's actually what it's there for. Lots of people sue, it doesn't mean they win. It means things get tested and evidence gets put. We're getting well off track there and defending legal system, but certainly to come back to Richard's comment, yes, they certainly do seem to to each other a lot. And I mean, you think we have jurisdictional problems here? Can you imagine what it's like over there? 52 states and however many police and fire agencies. So no wonder they're all fighting with each other, where budget issues and cooperation is so much more complex. So we don't want to look at their civil litigation aspects. We want to look at, as you say, their post-event inquiry. And if you've read anything about the inquiry into the death of the 19 firefighters, the hotshot crew, people are not very happy with that inquiry. And one of the reasons they're not very happy with that inquiry is it didn't come out and blame anybody. It said, you know, we're not exactly, what it actually said was, we're not exactly sure what happened. It's a bit hard to know what happened because nobody survived to tell us, tragic as that is, but that was their point. There's now been a work health and safety type inquiry that's placed some blame somewhere. So, you know, if you read the press, people are feeling better about that. I think that's a tragedy, that we feel someone's got to be blamed, and whether we can come up with a model of post-event inquiry that can meet whatever that demand is without being at such a high cost, I'm not sure. Roshana said, you talked about inquiries related to bushfires that might be different with other natural hazards. Will your future study cover this area? Absolutely. Absolutely. I have on the panel of researchers that I'm doing a colleague, Dr. Karen Hussey, and we also have a PhD student coming on board. Karen is particularly an expert in water and water policy. She and her student wrote a significant report on living with floods and how we learned from the inquiries into the Victorian and Queensland floods. So yes, absolutely, we'll be looking out across those water hazards. I've talked about bushfires because, as I said, the research has been done by the Bushfire CRC to date. We're moving into the new bushfire and natural hazards CRC. Roshan's asked, can there be a common model of inquiry for all hazards? Don't know yet. I wouldn't know why not. But I don't know. I think just in response to that question, there are two issues. If I go back a slide or two, hang on. If I go back to that slide, I think that could be a common model for hazards, but what the specialist panels are would vary. So whether you're looking at a flood, where it's unlike a fire, isn't it? No one ever expects anyone to stop a flood or stop a cyclone, but you've got to worry about how well prepared the community was. Whereas when you have a bushfire, there's this whole question of could it have been extinguished earlier or controlled better? So there may be very different specialist panels, but as a model, I can't see why that wouldn't work for all inquiries. I think that sort of CASA model that we're talking about is much more when you're looking at human contributions to these events, and particularly the response. So can there be a common model of inquiry for all hazards? That question is always, you know, it depends how general you get. In one sense, you can say, well, there's the Royal Commission. It's a common model of inquiry. We use it for all sorts of hazards, floods, fires, storms, gas explosions in Melbourne and West Australian coast and things like that. But in their detail, they're always different. In there, that's their terms of reference. Can there be a common model of inquiry? I expect so. Exactly whether that's so or not, I'm not sure. All right. I'm being given the wind-up notice, and I look at the icons. No one seems to be typing. And the time is right. So I think it's probably time to wind up now. I thank you, everyone, for making the time to come in or go wherever you needed to go to access a computer at 7 o'clock at night, our time. and remind you there's an exit survey on the way out to comment on both this webinar and what else you might like to see. So at that point, I put up that slide, contact details if anybody wants to get back to me, and thank you for your attention.